The NEC is minimum, so the AHJ could require more. And people say this a lot in comments where you are arguing with a decision from an inspector because it's not code. Well, think about this in two ways. First, just rationally, like at a high level. If this was true, if the AHJ could require whatever they want, and the insinuation here is that the inspector could require whatever they want to create whatever they consider to be a safe installation, you're absolutely screwed and you can't quote anything anymore. I mean, say for instance that you run an entire installation in EMT and then the inspector comes along and said, no, I prefer that everybody run it in rigid. That is a huge cost to fix. So giving that kind of power to an inspector, even just a little bit, that's a problem, and it's not supported by any jurisdictions that I know. The fact of the matter is, the AHJs pick the NEC as their basis for proper installations. And if they want to go above and beyond that, they will have amendments that are ratified, things that you can go read, things that the inspector should be able to reference. And if they can't do that, then they're wrong. Like, a lot of you think of the NEC as, oh, this is just the law of the land. NFPA picked this law for everybody to choose. But the states have the option to pick whatever safety code they want. They could pick the Canadian code for ratification in their state guidelines. Wouldn't maybe make a whole lot of sense, and most people use the National Electrical Code because it is very America-centric. But they could pick the Canadian code and put that in the state law. But they don't. They pick the NEC. They could create their own code to make it go above and beyond. But they don't. They pick the NEC because it is a good, solid, practical minimum standard. Minimum does not mean bottom of the barrel. It means very safe. I said we'd talk about this in one of two ways. The second way is let's look at the code and see what it says about AHJs enforcing this stuff. In terms of enforcement, the code is intended to be suitable for mandatory application by a bunch of these people. The authority having jurisdiction for enforcement has the responsibility for making interpretations of the rules, for deciding on the approval of equipment and materials, and granting special permission contemplated in the number of the rules. So it can interpret rules, but it doesn't mean that it can make rules up. By special permission, the AHJ may waive specific requirements of the code or permit alternative methods, and it notes that the code may require new products, constructions, or materials that may not be available at the time the code's adopted. This has happened, especially in solar, and in that event, the AHJ may permit the use of products, constructions, or materials that comply with the most recent previous edition of this code adopted with the jurisdiction. The other thing people cite is mechanical execution of work. Electrical equipment shall be installed in a neat and workmanlike manner. Doesn't mean that you can require something entirely new with the code, doesn't mean that you can add requirements. So the AHJ picks and enforces the law. It cannot just come up with new ones whole cloth unless it's in the law that it can do that.